kind of tort situations you might run into in a business setting. Now, we talked about some of the more, I don't know, I guess maybe you want to say out there kind of torts, the Wile E. Coyotes, the leaving the pliers inside of a surgery patient kind of things. Most of you guys probably don't have interesting encounters like that, at least I hope not. But you might run into some of these things that happen in the workplace. So one of them is intellectual property torts. And I think this is a really kind of a hot item that is only increasing as we do business more and more globally and as we use the internet more and more, all right? And this has to do essentially with taking other people's intellectual property and passing it off as yours or using it in a way that you're not allowed to do, all right? Now, if you watch movies, which I imagine all of you have seen a movie at some point or another, you see these things in the beginning, like these kind of FBI badges and things. And then they talk about criminal penalties, okay? So that's a whole different setting. I'm not aware of a lot of prosecutions for people ripping off movies, okay? Doesn't mean it couldn't happen. But what you really can get into with this kind of stuff is civil suits for damages. So I don't know how you guys steal your music these days, but when I was in college, we stole it with a thing called Napster, all right? And this is a peer-to-peer file sharing service. And I remember one day being in my room, and my roommate came in, and he's like, "You got to see this thing. This is incredible. Any song you ever wanted, and it's free." I'm like, "That's awesome. How's it work?" "I don't know. Just start downloading." And, you know, we had like our cable modem with 1 meg download speed, and we're all downloading all these great songs, and we're just like sitting there thinking, this must be too good to be true, you know? And it went on for several months, and then we started hearing about the record companies coming after people for downloading the songs was one thing, but making the songs available for download was the other. Because one of the things we didn't really understand, because we didn't read the directions, or, you know, who reads the click wrap, you know, terms and conditions. But one of the things we didn't realize is that while we were downloading those songs, we were also agreeing to host essentially a file server of what we had so that other people could download them. Hence the whole peer-to-peer kind of thing, okay? None of us got in trouble for that, but we quickly ran into people who were getting in trouble for that, who were getting demand letters from the record companies for $4,000 or $5,000 for the songs that they had shared, okay? You can't take other people's creative work and use it or share it without fair compensation. Now, a lot of times people will say, "Well, I'm not making any money off of it. Is that okay?" That doesn't usually enter too far into the analysis, and it's definitely not a safe harbor. Okay, so I steal clip art regularly for these presentations. I'm just waiting for the day I get some kind of notice on it, I guess. There is such a thing as fair use for copyright. It generally doesn't mean just taking it and using it. So you can get into civil suits with this kind of stuff. If one of you guys designed this logo and you see it here and you're like, "He's ripping me off," you know, you could possibly file a suit there, right? Now, you've got to show damages, but this is one increasingly common area for business torts. So copyright stuff, trademark stuff that usually would have to do with like logos, trade dress, things of that nature. We've all seen kind of like knockoff shoes or clothing or handbags or whatever. That could be trademark infringement. Patent infringement, that is going to be in the federal court system. Somebody steals your invention. Increasingly, plants are getting patented, like corn. There have been some cases where people have been sued by the big agricultural companies for stealing corn. If you have intellectual property, there are attorneys who specialize in helping you protect this stuff, especially when you're doing work internationally, because different countries have different laws on this. So it's important to protect yourself. And if somebody else is stealing your intellectual property, kind of the same thing. Okay? So those are relatively common torts. Fraud also encompasses some different kind of business settings where you might have a tort claim. Okay, there are different kinds of fraud. Different states may have different causes of action or the ability to file suit for different kinds of fraud. You know, in Iowa, we've got this common law fraud, which sort of encompasses a wide variety of behavior. And then we've got some specific things, too, like fraudulent misrepresentation. And that can come into play when you're dealing with professional. Like, I think I told you about the case where my client bought a home from a realtor and contractor who had built the home for sale, and there were a bunch of defects which they both knew about. They covered those up, and then they lied to my client, inducing her to buy the home. So we sued them for, among other things, fraudulent misrepresentation, right? They knew or should have known about these defects, and they told us a lie. Now, the rules and the precedent, the cases surrounding fraud can be different from state to state, but you're generally providing false or misleading information with the intent to harm the victim. In Iowa, you have to show that the victim relied on that false information in making their decision, and they were actually damaged by it. Okay? Fraud is a little bit harder to prove than something like negligence. Or there's also like a negligent misrepresentation and some other torts of that nature. It is an intentional tort. They're harder to prove. The good thing, I guess, if there is a good thing about being on the plaintiff's side of this, is that if you do get a judgment against somebody for fraud, it's an intentional tort and it's not dischargeable in bankruptcy. Which is important because fraudsters are often very good at using the bankruptcy system to get rid of their debts. All right? Like I said, this can come up in real estate, sales, finance, Wall Street, quite a bit, many other areas. Now you're saying, I've seen people arrested for fraud too, maybe in the Wall Street Journal, like this guy, right? What's that? Okay, well, there can also be criminal fraud, and the same actions could lead you to being sued in civil court as well as being prosecuted in criminal court, okay? But remember, those are kind of different and essentially parallel proceedings. We're really focusing just on the civil side right here. There's some other intentional torts that you can get into in a competitive environment, all right? And sometimes these have to do with stealing customers, or they might have to do with stealing employees or salespeople. I won't say they're common, but you definitely should be aware of them so you don't do it, and so you recognize what's going on if one of your competitors does it to you. All right, so we've got this wrongful interference with contract, and then the wrongful interference with business relationships. The contract might actually be a little bit easier one to start with, okay? So if you know about a contract between somebody else and a third party, and you go and you get that third party to break that contract, and you damage, I guess it would be the second party, with that can be wrongful interference. Sounds very abstract, but let's use a more concrete example. So suppose you're a Packers fan, right? I am. And you think, gosh, it would be really great if we had a really good wide receiver for our team. We've got some, they're not bad. But you think, Odell Beckham on the Giants. He's really good. It would be great to see Aaron Rodgers throwing passes to him. But he's under contract with the Giants. How's that work? Well, let's go over there and say that the ownership of the Giants said bad things about him. We'll get him to fake an injury, and he'll be released by the team, and then we sign him. Okay? That would be kind of like wrongful interference with contract. It's not usually that dramatic, but sometimes I know I've seen this happen with like radio or TV personalities. You know, one media group might want to steal somebody from the other one, so they will convince them, you know, break your contract with those guys. We'll pay your legal fees, whatever. We'll pay some damages. Just come over here. All right. So it is tortious conduct. You can be sued for it. Wrongful interference with the business relationship is like a little step back from that. Okay? And the difference is there's no contract, but there's a relationship that has kind of the ongoing expectation of profit. All right? So maybe you're in the business of selling metal buildings, and you notice that all the farmers in this area consistently buy from this other manufacturer. So you go to those farmers and you say, yeah, you know, I know you guys like to buy from this group when you, you know, are expanding your farm, but here's a bunch of really bad things about them, and you should buy from us instead. You know, they're dirty, low-down rascals, and, you know, I think their quality is terrible, and da-da-da-da-da, whatever. Okay. I actually litigated a case like that, and that's why I used that example. It's harder to prove because you don't have the contract and the subsequent breach. But if you can show somebody is maliciously interfering with your business relationships or preventing the relationship from developing in the first place using predatory behavior, you can win these. That's a pretty high bar. So I had a client call me once from a trade show. Let's just say they sold metal buildings, because they did. And they said, we're at this trade show, and one of our competitors is at the booth down here, and people are walking around, and they're saying their buildings are much higher quality than ours. I want to sue them. I said, I'm sorry, there's nothing that we can do. That's just competing, okay? They're just sort of giving their opinion. Now, if they were saying, you know, kind of like false, malicious, predatory, untrue things about your product, maybe we'd have a case. So I've got a couple examples in here that you can kind of look through. This is one where a guy is trying to sell some land, and he's got it listed for sale, and somebody else is telling people that there's criminal activity on the site. The property is hot, and the site is currently under investigation. Okay, so those kind of things, I guess, could lead you to a claim for this. No word if they won or not. All right. So those are the wrongful interference torts that we usually think about. It's kind of one of these often threatened, rarely actually gone through with kind of things, because the bar is pretty high. Now, if it actually happens to you and you have damages, you can go through with it, but from the plaintiff's side, it really sounds better than it is most of the time. Defamation and the categories of it, libel and slander, again, are something that is often threatened, but rarely successfully brought as a case. I was pulling up a video that I'm going to show you guys in a minute, and there was the suggested videos on YouTube, and it said there was one that says how not to get sued for libel and slander. It was from something called freeadvice.com. I thought, free advice is usually worth what you pay for it, right? I looked at it. It looks like they have some volunteer lawyers, but I guess I'll give you some actual advice how not to get successfully sued for libel and slander. Now, if you use the internet at all, and you like to argue like I do, somebody is probably going to threaten you one day with, that's libelous, that's slanderous, okay? But the truth is, the elements of this tort are very specific. And to win a case, they've got to prove all the elements. Now, I think I've said this a couple times before. Anybody can sue anyone for anything at any time for any reason or no reason. It doesn't mean you're going to win, okay? People literally sue the devil. They sue celebrities they've never met, right? There's a whole bunch of interesting and odd people out there. It doesn't mean they're going to win, okay? But if you do wish to sue somebody for defamation, you have to prove these specific elements. I cannot tell you how many people, plaintiffs, I have talked out of defamation suits because they're really hard to win. I don't believe we've ever brought one. I've never tried one, okay? In general, defamation is wrongfully hurting a person's good reputation. So, good reputation. What does that mean? Well, first of all, the person has to have a good reputation. But this is an interesting one because there are extremes. Courts have held that somebody can have such a good reputation that your defamatory statements cannot harm them, okay? Mother Teresa, if she were alive, would have a pretty hard time bringing a case for defamation. Courts might hold her reputation is so good. Conversely, courts have held that some people's reputation is so bad that they can't sue for defamation either. I'm not going to give any examples. All right? So you got to have something in the middle, okay? You've got a good reputation and it's been damaged wrongfully, okay? Not that it's just been damaged. So if you say something truthful about a person that they actually did and it reflects poorly on them, that's not defamation if it's truthful, okay? Because it has to be a false statement of fact. The publication requirement applies as well, okay? So ways to, quote, publish this could be saying it to a third person about somebody else, emailing it, tweeting it, Facebook, I suppose Instagram if you're really creative, right? And you don't have to necessarily intend it be published to a third person. If you send a nasty defamatory email to someone and they turn around and republish it, you can still be liable. Okay? Now it's rare. I don't know who or why someone would do that. But it's possible. And the standards are going to be different when we talk about public figures. So we're going to get into that a little bit with the Sullivan case. But I mentioned there's essentially two different kinds of defamation, or we can lump it into two different categories. Slander is one. Slander is spoken. That's how you can remember it. They both start with an S. All right? Slander is spoken defamation. And if you say something bad about a person, and that's in the presence of a third party, and they hear it, and it's defamatory, then you could be liable. All right? So if you are alone with the target of your defamation and you just say, you know, no one's around, but you're a real so-and-so, and I think you stole a bunch of money from the bank. That wasn't yours. I don't know. Whatever, however you like to defame somebody, right? If it's just them, it's not published, all right? But if there are other people around, it's going to be published. When you go to look at damages, now you've got an interesting issue as the plaintiff. And this is the main reason I usually talk people out of filing these suits. What are your damages? Well, this guy said I was a liar and a cheat and a dirty scoundrel. Okay, what were your damages? Well, made me feel bad. Not actionable in court. Or I get people saying, well, I think my old boss said defamatory things about me because I applied for another job and I listed him as a reference and I didn't get that other job. And I think they must have said something really bad about me because I was totally qualified for that job. And I say, okay, can we prove causation, right? Because remember, we've still got, these are torts, duty, breach, causation, damages, right? Duty is not to say false defamatory things. Can we prove the breach, and can we prove that you would have got that job but for this alleged statement? Well, no. How would we do that? Well, I don't know. I guess we could call HR at the new place that you applied to and see if we can get them to say, yeah, we would have hired him except, which is never going to happen. All right? So you have to prove some damages. That's called per quad. In other words, these are category of special damages that you actually have to link it to a monetary amount. There are some rare cases where we find slander per se, no proof of special damages required, and they're old-timey. All right, so if you say someone cheats in business, has committed a serious crime, which is usually read as a felony, has a loathsome disease, these are the real words, or is an unchaste woman. In other words, a woman is no longer a virgin. Okay? Damages are assumed there. How much? Probably $1. Okay? So if you want to bring, if somebody says so-and-so has a loathsome disease, and by that what they mean is a sexually transmitted disease, you have to show, you may win $1 to sort of vindicate your rights, but if you want many dollars, you're going to have to show that that cost you some kind of opportunity or caused some damages. Libel is the written form. Okay? Now, libel is a little bit easier to prove, obviously, because you've got a writing out there somewhere, whether it be something in the newspaper, whether it be an email, a tweet, a text message, whatever, okay? So you're on a little bit better basis for your evidence. Still not often won, all right? This is a suit from 2014, and I thought it was just kind of interesting. A high school basketball coach sued a parent from that high school because the parent was sending emails around to school district officials and fellow parents saying the coach was not doing a good job in some way. All right, so he sued the parent for $1 million. Apparently, the parent allegedly accused the coach of violating child labor laws. Too many practices? I don't know. Seems interesting. I don't know how that turned out. I'm going to guess the coach didn't win, though. That doesn't seem like a great suit. Most of these are pretty difficult to win. So I want to show you a really quick video. We got just 2 interesting videos today. These are actors. Mustache may or may not be real. I'm going to go with real. But you're going to see an attorney and a potential client. And this is a lot of what it feels like to be an attorney most days. So let's watch this. That's how most of those conversations go as an attorney. All right. Hey, free advice guy. All right. So it's got to be false. All right. It's got to be false. Now, if you're a public figure, things change even a little bit more, okay? You're going to have a harder time winning a case for defamation if you're a public figure. So this would include public officials like police and politicians, movie stars, celebrities, pro athletes, but it usually comes up in the context of politicians, okay? And if you are a public figure and you wish to win a defamation suit, you have to prove the defendant acted with actual malice, all right? And that's usually kind of like a reckless and possibly knowing disregard of the truth. So the kind of the key case for this is New York Times versus Sullivan, okay? And this concerns a full-page ad taken out in the New York Times in the 1960s, and it said that the arrest of the Reverend Martin Luther King Jr. for perjury was part of a campaign to destroy his efforts toward integration, okay? And so in other words, it was criticizing the public officials who had him arrested in Alabama. The city commissioner of Montgomery, Alabama, Sullivan, filed a action for libel against the New York Times and 4 ministers who were endorsers of the ad, saying that this is defamation. You're saying I arrested someone wrongfully, okay? Under Alabama law, he didn't have to prove damages per se, so it proceeded past what would have normally been kind of a summary judgment motion. And the ad did have some factual errors, so truth was not available as an affirmative defense. And so Sullivan won a $500,000 judgment against the New York Times newspaper for this. All right, so this was appealed all the way up to the U.S. Supreme Court. And the Supreme Court looked at this and they said, okay, these Alabama laws that allowed him to essentially not have to prove actual damages and that held this to kind of the same standard as if he were a ordinary private person shouldn't apply here, okay? A public figure is going to have a higher bar to win a defamation case, okay? Some of the reasoning, of course, you can read through this, but there are a lot of news articles published about public figures. Sometimes there are errors, sometimes intentional, but more often unintentional. And if we had a lawsuit every time there was a misprint or an unintentional error, that would greatly encourage litigation, and it would really kind of infringe on the ability of news organizations to do their reporting, okay? And so the court read in a First Amendment protection here, saying that when you've got freedom of the press, when you've got a public official and news organization makes a false statement, they can only be successfully sued when there's actual malice, knowledge that the statement is false, or reckless disregard of the truth or falsity. All right, so I think this is a good case to read, and if you look, I've got a link to a summary, and you can read the opinion if you like. You don't have to read the whole thing, but I think the summary is useful. But I think it gets back to this idea where if somebody is a public figure, they're going to have to go a little bit further to win a defamation case. All right, so it's not like you or me. I assume nobody in here is holding public office or famous, right? Somebody defames us, we've got kind of the lower standard. If you're a public official, if you're a mayor, a police officer, a governor, whatever, you've got to show actual malice, okay? So even though these kind of suits are threatened, quite often It's very rare to see somebody go all the way through with it, and it's even rarer to see a win. Okay? So when we look at the defenses, the attorney actor in the movie, talked about some of these. Truth is a complete defense. All right? So if what you said that harmed somebody's reputation was true, they cannot successfully win a judgment against you for defamation. Doesn't mean they can't sue you, but they should not be able to win. It has to be a statement of fact. So satire and opinions generally don't fall under the definition of defamation. However, you can't get too cute with that. All right? So sometimes somebody might write a story, or maybe it would be a blog or a letter to the editor and say, it's my opinion that I saw so-and-so stealing cars. You know, it's my opinion that this person cheats at business, and in my opinion, they have a loathsome disease. All right? Now, are those really statements of opinion? No, you're just putting the words "in my opinion" in front of them. All right? It's intended to protect kind of a genuine equivocation, saying, you know, maybe this person isn't taking the right approach, or whatever. That might be more defensible. But generally, it does have to be a statement of fact. And then there are certain times and places where you have the ability to say whatever, even if it is defamatory, without fear of being successfully sued for it. So if you're in court and you get called as a witness and you have to testify, how could you testify fully and truthfully under oath if you're worried that what you say is going to get you sued later by the person you're testifying against? You couldn't. All right? So you have an absolute privilege in court. Our lawmakers, when they're debating, right, in their legislative sessions, they got to be able to say what comes to mind without fear of being sued over it. So the absolute privilege is limited. You know, those are kind of the two main areas that I would think about, lawmakers and in court. There can be some qualified privileges too. And these vary a lot state to state. You have to know them. So Iowa's got like a qualified privilege for job references. You know, the scenario I gave you before. What if you work at a company and you have to dismiss an employee because they embezzled money from you. They stole money from you and they were convicted of it, okay? And then they go and they apply for a job in another town, and that new company calls you for a reference. Are you allowed to say, well, yeah, they were convicted of theft related to the money they took from here? Yeah, you've got to as long as that's true, you've got a qualified privilege there to say those kind of things. But you have to, you know, be careful and figure out the boundaries of that. So generally, if there's no malice and you're doing it to protect legitimate interests, not just to harm someone you don't like, you're going to be on decent ground. So let's talk about damages in tort and defenses overall. All right, and this kind of ties in with some of the categories that we've already talked about. I've kind of mentioned some of these damages, but it's going to be useful for us to know these for the next couple sections as well. All right, these are kind of pretty key vocabulary terms. Compensatory damages comes from compensation. All right, the idea with compensatory damages is to make you whole again, right? To pay back what you've lost. No more, and hopefully no less. All right? We have something called the single recovery principle in American law. You might also hear it called like one bite at the apple. That's a weird thing, because I mean, who eats an apple in one bite? But okay, or who takes one bite only and then stops eating an apple? It's better to call it the single recovery principle. And this is the idea that if you have to bring suit for damages, you better figure out what all those damages are, because you only get one shot at getting those back. All right? So consider an incident where, I don't know, I guess I'll use an example from my personal life. When my wife and I were in law school, she was riding her bike to school. and she was hit by a car, okay? Thankfully, was mostly okay, but she, ambulance came, took her to the hospital, didn't break any bones, but had some injuries and things, kind of scraped up. We had a bunch of medical bills. We had, thankfully had health insurance, but still a lot of deductibles and things. And, we asked our law professors, like, what do we do? Do we, call a lawyer? Like, how do we get these bills paid for? Because it was the driver of the car's fault. And they said, well, here's a couple lawyers you can talk to. So I call one of them. And he says, okay, here's the thing. You need to wait about probably 6 months before we do anything, because you don't know what kind of injuries she's going to have. Right now it might look like no big deal, but she could have a neck injury, back injury, something that's, going to flare up down the road. And if you don't know the scope of those damages, then you don't know what to ask for if and when it would ever go into a legal proceeding. All right? So if you see a situation where somebody is injured in an auto accident, and thankfully she turned out to be mostly okay, and the insurance company did pay for the damages, the other guy's insurance. But if you get into a situation, sometimes you'll read about these stories where, say, like a 25-year-old guy gets hit in an auto collision and gets a compensatory damage award of $5 million or something, and you think, wow, that's just an insane amount of money, right? He hit the lottery, he hit the jackpot. Well, not really, because how you compute those damages is you have to look forward at the rest of that person's life and figure out what they're not going to be able to do, okay? So maybe that person's going to need $10,000 worth of medical bills a year for the rest of their life, multiple surgeries in their future. Maybe they worked in a job where they were, had to be strong, use physical labor, and now they can't work anymore, so they have lost wages for 40 years. All of those kind of things you have to figure out if and when you have to bring your lawsuit, because whatever the judge or the jury decides you get, that's it. You don't get to go back and ask for more. All right? So suppose you make your suit, you ask for $50,000, and then 2 years later you find out, gosh, I need my hips replaced now because of this collision. Do you get to go back and ask for more? No. All right? One award, if there is one at all. So you have to roll in all the past, present, and future damages. All right? So mostly what we think about in tort cases are restoring any kind of loss. So if it's physical harm, then it's your medical bills. If it's financial harm, like a fraud case, it's the money that was taken from you. All right? Lost wages, and then pain and suffering. And again, if you're going to establish pain and suffering damages, you have to do that with expert medical testimony, which is not cheap or easy to do. Punitive damages. So this is where things look a little bit different than what we normally think about with civil cases. I told you with civil cases, we've got private parties suing each other for money damages and maybe asking for injunctive relief, the court telling somebody, do this or don't do that. All right? Punishment sounds like a criminal law concept, right? Yeah, generally it is. We talk about punishing criminals for the harm they did to society as a whole. But there is a little bit of that element in certain tort cases as well. Sometimes a person or a company or even a government does something that is just so incredibly stupid and wrong that we assess additional financial damages against them in order to punish them for what they did, deter them from doing it again in the future, and to set an example for others so that they don't do the same stupid thing. If you guys are familiar with the case of the Ford Pinto, it's always risky to Google things in front of a class, but let's just just do it real quick here. This was a car that was made in the 70s. And yeah, this is the one with all the flame. All right. Just skip ahead to the good flaming part. This was the most popular car in America for a while. It had a little problem. If it got hit, and this is a pretty serious collision, but if it got hit at like 20 miles an hour or more, there was a defect in where the gas tank was located, and it would burst into flame. Oh, this is one of those weird robo-voice videos. Okay. So just kind of picture that flame, right? So if it got hit at like 20 miles an hour or more, simple fender bender speed, it burst into flame, and it killed the people inside generally. Ford found out about this, and they made a calculation. This was one of the top-selling cars in America, and they figured out what it would cost to do a recall of all these millions of Pintos. And then they made another calculation, and they thought, well, if the average person who dies in one of these, their funeral is going to cost this much, some damages to settle to the family, a couple thousand, is this much, and they came up with a number over here. Okay, this is going to cause X number of deaths, and we're going to pay like, I don't know, 5,000 or 6,000 per was what they thought, something in there. Or the recall is going to cost us this much. And in their initial calculation, the recall costs more than paying for the deaths. So they said, we'll roll the dice, let people die. Okay? So they did. They didn't do the recall. And somebody wrote this down in the meeting notes. Worst intern ever. All right? Somebody wrote that down. So the first time that came to trial, they had a little discovery. And they found the memo. And they found this thing saying, yeah, we figured people were going to die, but it was cheaper to let them die than to fix the problem. And our old friend Punitive Damages walked in the door. And all of a sudden, their equation went way wrong, because it was like $117 million in punitive damages for just the first case of many. Problem, okay? Almost put them out of business. So that's a great example of when you assess punitive damages against a company. Outrageous and extreme conduct, you're trying to make an example out of them, and you're trying to say, we don't ever want another Ford Motor Company doing this with the Pintos again. All right? That's a good example of that. Now, we've also got this concept of contributory negligence, and this is essentially saying, yeah, I hurt you, but it was partly your fault too, okay? I see potential examples of this every day because I drive down the one-way street here to park, and then I park, and then I walk across that street. And if you look out there, what you're going to see is you're going to see a lot of frustrated motorists trying to drive down there, and then you see students and professors walking down playing with their phone, right, as they cross the street, not really paying attention. So suppose you're on your phone, and you walk out in front of a car, and they hit you. You're saying, well, it's a crosswalk. They're supposed to stop. Yes, that's true. You're also supposed to not walk in front of traffic, okay? So suppose your case gets to a jury, and they look at it, and they say, well, yeah, the driver ran him over. It was in a crosswalk. That's a problem. But they were also on their phone, and they weren't paying any kind of attention, and they walked right in front of it, of the car that was coming. How do they deal with that? Is it an either or? No. Generally, what they're going to do is figure out who's to blame and what percentage, and they're going to reduce the award by that percentage. So if they figure, okay, it was 20% the pedestrian's fault and 80% the driver's fault, then they're going to take whatever damage award and just reduce it by 20%. Right? That's comparative negligence. In a few states, they have the rule that if the plaintiff is at all at fault, you get nothing. I don't know those states. Iowa is not one of them. Iowa does have kind of this tipping point, though, okay? The modified comparative negligence rule. And this says if you are more than 50% at fault in the case, and you're the plaintiff, then you don't get to collect any damages, all right? So whatever you think of it, that's the law. So, if you're on your phone, you got your headphones in, maybe you're walking backwards with your eyes closed, and you go into the street where there's not a crosswalk and you're crossing against a light, and you get hit by a car, and the jury comes back and says, this was 90% the plaintiff's fault, the pedestrian, and 10% the driver's fault. In Iowa, under that modified comparative rule, you get nothing because you're across that 50%. Okay? Now, what about some of these other things that can kind of modify an event? Whenever I think about torts, I kind of think about the sequence of events resulting in injury, and you got to think about cause and effect. All right. So superseding cause. If the actual damage was caused by something that comes in from nowhere and causes an injury, then that's going to be a defense. So you take somebody out on your boat and you're boating on the Mississippi, and then a piece of satellite falls out of the sky and kills them. Is it your fault because you were boating? I think it's a pretty good case of superseding causation. They always taught us with examples of things falling out of the sky, whether it was a piano or something else. I don't know. I guess that's where those things come from. Assumption of risk probably applies to some of the stuff you guys did over spring break. Maybe you went somewhere warm and you were going to go like parasailing or rent a jet ski or rent a four-wheeler or a jet boat or something like that. And if you did, they probably gave you a form to fill out, a waiver form that said, you understand the inherent risks of this activity. You could get killed, you could get dropped from the parachute, whatever, you agree not to sue us. All right, so that's like an explicit waiver. And in general, those are going to hold up in court as a defense. You can waive sort of the known and ordinary risks of an activity. All right, now if they do something crazy, like they put you up in the parasail and throw snowballs at you, which used to happen to my cousins and I when we would parasail on the ice in Wisconsin, that might not be covered, okay? But just sort of the ordinary risks. And then there's just some things that, like any normal, reasonable person would know are inherently dangerous. If you go bullfighting, if you run with the bulls in Pamplona, you go downhill skiing, bungee jumping, parasailing, all of these things, and you get hurt, a court might look at it and say, look, you were running with bulls. Bulls are big, angry animals. You got hurt, no kidding. All right, you assume the risk. Okay, so those are things businesses can use in their defense, or people can use in their defense. And then the last one has to do with a pretty famous case that I want to show you a very brief video on. It's the Palsgraf case, and this introduces the doctrine of unforeseeability, all right? So Palsgraf, we're going to see a little video here in a minute, but you have a lady in a train station. She's going to be represented by some Lego figures, all right? She's in a train station, and she's waiting for the train, and she's by a scale. I guess it must have been a luggage scale or something. It's a big chunk of metal, all right? Somewhere down the platform, and if you've been in New York, you know these train or subway platforms go for a long way, kind of like a really long hallway. Somebody down there is running to catch a train, passenger, right? And he's running, and he's going to try and jump on the train, get on there. A railroad employee sees him, and instead of arresting him, as he probably should, he tries to help the guy up on the train. The guy doesn't quite make it on the train, and the briefcase that he's carrying falls, and it's got explosives in it. This just gets weirder and weirder, right? This is a really old case, 1928. I guess people got on trains with explosives then. All right, so it falls. The explosives go off, and it sends this like shockwave down the platform. It hits the scale, and the scale falls on Miss Palsgraf, and it injures her. So who does she sue? Do you sue the guy who's jumping on a train? He's such a poor planner that he can't even make the train at the right time, and he's carrying explosives. You think that guy has a lot of money to pay your medical bills? Probably not. Do you sue the railroad employee? Well, that guy's working for a railroad. Has he got a lot of money? Probably not. No, you sue the corporation, right? The railroad. They hopefully have insurance for this kind of thing. All right? And she says, look, it was your employee that did the action. If you hadn't tried to help that guy up, the guy wouldn't have dropped the suitcase, wouldn't have blown up, wouldn't have sent the shockwave down. All right? So let's watch a little video that shows how this goes. There's some outdated political references in here. It's from 2009, but they're kind of cute. So let's go. One of my favorite videos. I didn't make it. I wish I had the patience, though. So you got a little flavor there of the case, and you heard from Justice Cardozo for the majority, and then the second judge spoke in dissent. Okay, so the idea here with this foreseeability doctrine is that if you don't have any inkling that the action you're about to take can harm that other person, no reasonable foreseeability of that, then you can't be held liable. Okay, so remember, this is a lawsuit between Mrs. Palsgraf and the railroad corporation. It's not between her and the Jolly Fool. It's not between her and the railroad worker. It's her and the corporation. So you've got kind of multiple actors between plaintiff and defendant there. And so Justice Cardozo found, at that time I think Judge Cardozo in the Court of Appeals, found that, you know, this is just, it's too weak of a connection. It was never foreseeable. The dissent says, well, this is kind of just practical politics. You're making an arbitrary distinction here and just saying, well, in this case, it's too far apart, you know, but where's the bright line, all right? But the majority opinion is what creates precedent, not the dissent, and this continues to be the law, you know? And so when you look at a hypothetical, like on the exam or whatever, you've got to look at, is this foreseeable? All right? Not is it foreseeable in a cartoon Lego world, but in real life. Can these things, you know, if I do X or fail to do X, is that, you know, really foreseeably related to this eventual injury? And so we're kind of putting a limit on your liability as far as it goes out into these multiple steps and multiple actors. All right. So that'll do us for today. Enjoy your weekend. We'll see you next week.